Hello friends, welcome back to Pen and Paper YouTube channel. So we believe that even complex legal issues can be explained with just pen and paper. So today we are going to discuss a sensitive topic, that is, can your employer legally monitor your WhatsApp, email, or even can he find out if you're going to interview somewhere else? What are the legal limits in India? So let's break down this topic. And in case this kind of scenario, if it is going to happen with you, so what are the legal remedies you have? So let's see. And first we need to understand what is employee monitoring to understand this concept. So friends, employee, that is the monitoring, which can also happen in office or remotely it can also happen. So basically, the employer is going to check your emails, that is the email tracking, and the WhatsApp surveillance if in case you are going to log in into your work devices. So definitely the employer or the company to whom we are working, they have the access and ability to check and what is the internet usage, for what purpose you are going to use your internet, and also they are going to have to access to the remote desktop access. So basically whenever you are working for any remote client, so here whatever you are working in the client system, so that also your employer can check, and they can also have the access to webcam or the mic activation in your system, and also the job search tracking via device logs or the calendar access. So this can also be tracked very easily by the employers. So basically, the employers are going to use various tools, but again, at what legal basis they are doing this, and what is the thing where the employee can also uh, have the legal basis. So likewise, we will be discussing an example here. So basically, there is a company XYZ, and they are going to notice in their employee, that is the browser history, that is he has like done or scheduled a Zoom interview, and basically this is something which the employee was not supposed to do in the company's that is the devices what they have given, and can they act on it, and let's see what are the legal ways or the law going to say whether it is going to support the employee or the employer. So now we will try to understand what is the legal framework in India. So friends, India's privacy laws are going to protect the employees even they are going to work during the remote work or the job search they are doing. So in case if something which is going to happen, you need to be like aware of the legal scenario as well. So the first one is the Information Technology Act, that is year 2000. So here section 72 is going to deal with the breach of the confidentiality. So if in case any employer who is going to breach the confidentiality, so this act and this section is going to attract for the employer and they are going to held punishable for that. And the same with the Information Technology Act, that is 2000. There is also a reasonable security practices and procedures and sensitive personal data or information rules, that is in the year 2011 we have this. And in this there is going to be the consent for sensitive data. If in case somebody wants to use your sensitive that is the identified data, personal identified data, then definitely they need to have the consent of the employee first, and then they need to process that sensitive data. So the next act which is going to cover the protect the employees is the Digital Personal Data Protection Act, that is in the year 2023. So here it is going to mention what is the purpose, limitation, transparency, and lawful processing. So this is also going to support the employee if in case their data or their information has been misused by the employer. So the next is very important. So under the Constitution of India, Article 21 is going to mention about the right to life and personal liberty, and which is also going to interpret to right to privacy. So our constitution is also going to cover and protect the right to life and personal liberty, which is also going to mention that right to privacy. So anyone who is working, is an employee, then definitely his rights are going to be covered. So the next one we have is the Supreme Court ruling in KS Puttaswamy. This is Justice KS Puttaswamy versus Union of India in 2017. So here Supreme Court mentioned that the privacy as a fundamental right, and surveillance, if in case any employer is going to put a surveillance on his employee, then that should be a lawful, and then it is going to be the limited surveillance, and then it should be justified by the employer. If in case any misuse which is going to happen, they need to justify why that surveillance has been done, whether it is in the lawful limits, and what is the purpose they have um, done the surveillance. So now we will try to understand the remote work surveillance, and then we will also understand what is happening. So friends, remote work has also led to a new form of surveillance by the employers. So basically what they will do is they will track the time using some of the softwares in the system, such as the Hubstaff and Toggle. So these are the some of the softwares which they are going to use in the employee systems, and then they will start tracking the time, how much time the employee has spent on his system. And there is also the screen monitoring. So whatever the work the employee is doing, so they are going to track it and they are going to monitor what the work they are doing. So example is the TerraMind, and there is also Active Track. So these are the example softwares which they are going to use, and the employers are also going to have the access to webcam. Even the webcam is like off from the employee, so they have the access to make it on and get what the employee is doing, and also the mic access. So what they are talking, what they are doing in the background, even though when they are working. So then definitely these are all the things how the employees are going to be monitored by the employers. And so basically these tools are legal if they are going to be like disclosed and consented to used. Basically the permission from the employees, basically they also need to be aware, the employee, that these softwares are being used and they are being tracked. So basically when we speak about the VPN logs and keystroke tracking, so basically this should be disclosed. It is used for the legitimate, that is the business activity and the purpose, and the consent from the employee need to be obtained prior doing the surveillance. So the employees also need to be very much careful whenever they are working remotely or from the work from home setups. So they are in the home and they are working from the home, and if the employees start doing the work surveillance in any of these forms, then definitely their personal life, what they are talking, what uh, how they are in their home, so everything is going to be recorded. Even the audio, the camera is also going to be help there. So now we will check with an example like how the surveillance is going to happen. So there is an IT firm XYZ. So what they are going to do is they are going to use the one of the software that is called as Active Track to monitor the employee who is working on a software, who is going to code a software, and they want to check how many time he has spent on coding the software. So basically the employees are informed, and then the consent is also taken by the employer by the one of uh, the contract, which is going to specifically mention that there is going to be a software in their systems. So they are also going to monitor them, how much time they have spent on the coding of the software. So likewise the employee the employer has already been consented by the employee and they also have the contract. So this kind of surveillance is lawful. So next what we will be checking is we will be checking the WhatsApp monitoring whether it is legal or not. Let's check. So friends, here the WhatsApp monitoring is a bit tricky one. So if any of the employee who has been given a company device and he is using the WhatsApp for the purpose of the work what he is doing over there and with the clear policy that it is going to be monitored. So all these things are legal. And if in case for any business purpose also he is using the WhatsApp in that the company provided device, then definitely this is legal. And we will see what is illegal if in case the WhatsApp monitoring by the employee they have started with uh, the personal device. So here if the employee is working, that is using the WhatsApp in his personal device and the employer who has started to monitor it, then this is going to be the illegal scenario. And if the employer is doing this, that is the monitoring in the personal device of the employee without consent, so this is also going to be the illegal the thing what the employer is doing. And also the if they are having the access to the private chats and they are monitoring that as well too, then definitely this is going to be the illegal scenario from the employer to the employee. So now we will try to understand with an example. So there is a remote employee, so he is working remotely and who is going to use the WhatsApp. So he is using the WhatsApp on a personal phone to chat with family. So basically what he is doing, he is working remotely, he is having his phone, that is the personal device, and he is using that WhatsApp for the to chat with the family. So then if in case the employer is monitoring this, then definitely this is going to be the illegal scenario and the employer cannot legally monitor those messages what he is like using in his personal device. So now we will see what is email monitoring and what is allowed by the employer. So for the employer, what is allowed here and what is not allowed. So if in case the employer is going to have the surveillance, if they are going to monitor your work related emails, then definitely this is allowed, but also this needs to be done with the policy disclosures. And then if in case we try to see here what is not allowed by the employer. So if in case if they are monitoring your personal email accounts in your personal device, so that is not allowed. And if in case you are using any of the your company application in your personal device, if in case that tend to have access to your um, that is the monitoring, that also need to be disclosed by the employer and not done with the consent. So basically, you need to be very careful whenever you are using any company provided application or softwares in your personal device, and you need to be cautious whether there is a policy disclosure and also the consent need to be taken from the employee. So we will try to understand this with an example. So there is a remote worker or the remote employee. So what he does here is he is going to send the client update via company email. So he has sent an update, that is the client update using the company email. So the employer is going to track this one and for the company what he has sent, and they wanted to check what type of information the employee has sent with using the company email, that is the client updates. So this scenario is going to be the legal surveillance from the, that is the legal monitoring from the employer. So now we will try to understand a very important aspect here, that is the job surveillance. That is the job search surveillance. Is it legal? So if in case you are an employee of any of the company and you are looking for any of the jobs, can your employer have an surveillance where you are doing or where you are giving the interviews? So let's check this one. So now we will try to understand if in case you are searching the job apart from the regular, that is the job what you're doing, and the current employer, what he cannot do if in case you are doing a job search elsewhere. So first of all, they cannot monitor your personal job search or private devices. So basically, if in case you are using your personal email and the personal, that is the private devices, if in case they are monitoring this, so they cannot do this one. And they also cannot access your personal calendar or email. So basically, if in case you also have your personal device and in your personal email for your calendar, you have put for some meetings or any interview that you have set up. So in case if they are doing this, then definitely this is also employers cannot do without your consent. So first of all, this is not permitted. If in case also they are monitoring your personal calendars or emails without consent, so that is also which is not, they cannot do. So there are some scenarios where few of the companies or the employers, so they have penalized their employees just because they have like they have giving interview somewhere else. So this is the scenario. If in case some any of the employees or your manager or your HR in your company, if they just tell you that you went to interview, we came to know. So that's the reason we are penalizing you, and there is some deduction in your 1 or 2 days salary for this month. Definitely, this is also the not, they cannot do from their side. And so coming to what the employers can do. So basically what the employers can do is they can just monitor the company devices in case if they have provided any phone or the laptop or any company provided devices, so that they can monitor. And also they need to enforce non-compete clause, that is if in case you are working somewhere in the same time, you cannot work in a different company as well, because since you are working virtually and remote, so there are instances which have happened, the employees are working 2 3 companies and they are hiding their identity. So this also employees cannot do. And they need to make sure that the employers can just monitor the company devices. So now we will try to understand this with one of the example. So there is an employee, so he is working in one of the company, and what he does is, so this employee, he attends a Zoom interview. So basically there is also one more the job search what he was doing, and he attended the interview via Zoom and using his personal phone during, that is the lunch time. So basically the lunch time was there where he was currently working. So in that time he just used the Zoom on his personal device and he attended the interview. So the employer, what he did was he just the find out the employer, the current company where he was working. So he accessed his calendar through his personal email, and he found that he gave that interview during the office hours, and this is going to raise a serious legal and ethical concerns, because the employee is already in lunch break. If he is going to use his personal device for his personal interview where he is giving, so definitely this is something the employer cannot do. So you need to be very careful during your job hunt or the job search during one of the scenario where you are currently working. Never ever use any of the company provided devices, so that everything is going to be monitored. For the company provided devices, definitely the employers have the access to monitor them. So if in case the employer, if they are monitoring your personal devices, personal emails and your personal email calendar, so at what time, where you are going, what interview you are giving, which email you have received, so this is all the employers cannot do. So you need to be very careful. So now we will try to understand the consent and transparency. So friends, consent is not just a checkbox, it is also going about the clarity. So employers must explain what is being monitored. So they need to inform their employees that they are using so and so the applications for which the employees need to be aware of it, and how it is going to be used, why it is being monitored. So all the things and the information need to be provided to the employees. So they need to also define the scope. Basically, the scope will be for the risk and issues if in case any kind of data breach is going to happen, or any of the information which the employees cannot send or like share to the third parties. So the scope need to be defined very well, and they need to avoid the excessive surveillance. So employers, what they will be doing is just in the sake of monitoring. So they try to monitor the excessive surveillance, so that they need to avoid, and they also need to respect the privacy boundaries, because the employee is also having his family, his personal life. So anything beyond that risk is the legal trouble for the employer. So now we will try to understand with an example. So a remote work, if there is any employee who is working remotely, so a remote work contract includes the webcam access during meetings. So the remote work employee is using the webcam for the meetings, and employee is going to agree to this. So this is a valid consent. So the employers are going to tell the employee who are working remotely just to be available in front of the camera. They need to switch on. So this is a valid kind of the consent and the legal way how the employers can monitor during the meetings the employees. So this is about the consent and transparency. So now we will also try to see some of the case law spotlight. So here we will try to understand again Justice case Puttaswamy versus Union of India in the year 2017. So in this case, it confirmed that the privacy is a fundamental right. So every employee is going to have a privacy, and that is the fundamental right of the employee. And even they are working at work, the surveillance must be reasonable, and it should be appropriate and justified by the employer. And if in case they are giving any interview somewhere else, this is not going to count as misconduct from the employer, and it is the personal choice whether they continue to work in that organization or they can work somewhere else. So if in case the employer is also coming to know if an employee is giving any interview somewhere else, so this is not going to count for the misconduct. So now we will try to understand with an example. So there is an employee in a company. So what happened? So the company is going to penalize the employee because he attended an interview, virtual, or he went somewhere and the employer came to know that he is giving the interview, and the surveillance was excessive because this kind of monitoring is not legal and it is also not authorized. So the employee, what he can do, he can challenge this against his employer under the privacy law if in case he got terminated later on. So definitely he is going to question this in the under the privacy law, and the employer is going to head liable for this. So now we will also try to see some of the best practices for the employers. So basically what employers can do is they need to create the clear policies which are for the monitoring purpose. So this is the first thing what the employers need to follow up, and they need to also limit the access to the work related data. So the employee cannot access the work related data in their personal devices. So this is very important, and they need to also avoid the unnecessary personal surveillance just because they are having the surveillance and the employee is going to be monitored. So the personal surveillance is not at all required. So this is going to be come up in the remote setup work, again in the sensitive situations like job transition. So whenever they are moving out and they are in the notice period, the employees, definitely these are the few scenarios where the employer are going to they will be going the limits, the beyond limits, and the employers also need to train their HIR, that is the human resource people, on privacy compliance. So they need to make sure that how the privacy is going to affect and what are the things they are going to monitor. And just a mere mentioning that they are going to have the surveillance, the employee cannot be exploited. So now we will try to understand what employees should do. So these are the few scenarios where employees also need to be aware of. So they need to read the remote work or the contract for which they are going to sign with any of the employers. So first check what are the things they need to keep in mind, and also need to be aware that so these are the areas where the employers are going to uh, make the surveillance, and definitely they are going to like uh, be questionable for the scenarios. And the employees always they need to use the personal devices for private chats. So we have seen the multiple people or the employees who are working in IT and the private companies, so they are using the company devices for their own use. So somebody is opening the Gmail, the private Gmail in that device, or the WhatsApp or the LinkedIn. So definitely everything is going to be monitored because it is the company provided device. Definitely they have the right to access in those devices. And always whenever you are going to give the interview, never use the company device. Even though you have the time, you have flexibility, you know that nobody is watching you, but definitely things will get worsen if in case you will get caught. And the next is whenever there is any unauthorized monitoring, so you are working and you came to know that somebody is monitoring you without your knowledge or consent, then definitely this you need to report to your the supervisor or the managers who are above, and they need to be aware of this situation, that nobody is allowed to monitor you unauthorizedly. And the last thing is that you need to know your rights under the Information Technology Act and the Personal Data and Personal Protection Act. So these are the laws which you need to be aware of. And if in case if any kind of privacy is breached, you need to speak up and you need to inform to your related uh, the managers above, and they need to be take the appropriate steps how to resolve that. So friends, now we will be looking at the final takeaways. So basically the monitoring is legal, but it is not going to be unlimited monitoring, and the works especially for the remote work and the job search, so these need clear boundaries, where if an employee is working from his home, so the camera and mic access is provided to the employer just because they need the surveillance how the employee is working. So this is not the way how the employers must do the surveillance, and the employees also need to be aware of their rights. So if in case anywhere the data is being breached, you came to know that the illegal or the unauthorized monitoring is going to happen, you need to report then and there, and you need to also respect your workplace policies. If something is not allowed from your employer, You should not do those like your personal email or the access or the WhatsApp or your LinkedIn into your personal the work related devices, so that later you will be getting caught and you will be questioned for that. So friends, thanks for watching Pen and Paper, where we simplify the law with just pen and paper. If this video is like helping you and understand your rights at work and beyond, so give us a like, share with your colleagues, whoever in need of these kind of scenarios, and subscribe for more legal clarity. See you in our next episode. Thank you.